Congress. If it were possible for any one individual in the U.S. Congress to understand the entire history of federal income tax legislation, he or she could provide evidence that Congress has actually not breached the limitations set by the U.S. Constitution. The Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. But all duties, imposts, and excises shall be uniform throughout the United States. Article 1, Section 8. No capitation or other direct tax shall be laid, unless in proportion to the census or enumeration hereinbefore directed to be taken. Article 1, Section 9. These constitutional limitations very specifically prohibit any tax that is not both uniform and proportional. Indeed, a capitation is a head tax, one that is the same amount for each and every individual. While the federal income tax today is certainly uniform, it is not also proportional, since nobody pays exactly the same amount as everyone else. As a multi-generational body, Congress has kept much of its deliberations private from the public. Particularly with regard to income tax deliberations and legislation, Congress has kept the public in the dark both about these constitutional limitations and about the basic facts of income tax legislation. The basic facts are that Congress has very carefully observed these constitutional limitations, that it has very carefully deliberated about observing these constitutional limitations, that it has accordingly very carefully worded income tax legislation for the purpose of observing these constitutional limitations, and that it has accordingly very carefully not informed the public that there is absolutely no substance to the nearly immeasurable quantity of federal income tax legislation. To create the appearance of obligation to pay federal income tax, Congress uses indefinite words such as if and any. Where it uses definite words such as every and when, it does not establish specifics that lead to clear determination. Where it uses the words liable and liability, it does not establish specifics that lead to clear indication of obligation. For example, Section 1461, Liability for Withheld Tax. Every person required to deduct and withhold any tax under this chapter is hereby made liable for such tax and is hereby indemnified against the claims and demands of any person for the amount of any payments made in accordance with the provisions of this chapter. This is the first statute in the Internal Revenue Code that establishes a liability for income tax, but only if it is withheld first. The statutes under this chapter do not actually establish a requirement that employers withhold the tax, and no statutes in the entire code establish a requirement that employees or other individuals pay the tax. Section 6001, Notice or regulations requiring records, statements, and special returns. Every person liable for any tax imposed by this title, or for the collection thereof, shall keep such records, render such statements, make such returns, and comply with such rules and regulations as the Secretary may from time to time prescribe. This statute does not establish that every person is liable. Section 6011, General requirement of return, statement, or list. Paragraph A, General rule. When required by regulations prescribed by the Secretary, any person made liable for any tax imposed by this title, or with respect to the collection thereof, shall make a return or statement according to the forms and regulations prescribed by the Secretary. This statute does not establish that any person is made liable. Section 6321, Lien for taxes. If any person liable to pay any tax neglects or refuses to pay the same after demand, the amount, including any interest, additional amount, addition to tax, or assessable penalty, together with any costs that may accrue in addition thereto, shall be a lien in favor of the United States upon all property and rights to property, whether real or personal, belonging to such person. This statute does not establish that any person is liable. Section 6331. Levy and distraint. Paragraph A. Authority of Secretary. If any person liable to pay any tax neglects or refuses to pay the same within 10 days after notice and demand, it shall be lawful for the Secretary to collect such tax, and such further sum as shall be sufficient to cover the expenses of the levy, by levy upon all property and rights to property, except such property as is exempt under Section 6334, belonging to such person, or on which there is a lien provided in this chapter for the payment of such tax. Levy may be made upon the accrued salary or wages of any officer, employee, or elected official of the United States, the District of Columbia, or any agency or instrumentality of the United States or the District of Columbia, by serving a notice of levy on the employer, as defined in Section 3401, paragraph D of such officer, employee, or elected official. This statute does not establish that any person is liable. Basically, Congress counts on the individual not to pay attention to the simple language of the statutes or these simple facts, that the statutes do not actually establish liability for federal income tax. In cooperation with both the Treasury Department and the Supreme Court, Congress counts on the individual to assume a determination of liability and volunteer to pay. Where Congress includes particular language in one section of a statute but omits it in another, it is generally presumed that Congress acts intentionally and purposely in the disparate inclusion or exclusion. Rossello versus United States. One could argue that Congress has been less than honorable in its observance of the constitutional limitations on taxation, but it has nevertheless observed them very carefully. If it's okay for the U.S. Congress to comply with the U.S. Constitution privately, it's okay for you to enjoy your rights and privileges under the same U.S. Constitution privately. If it's okay for Congress not to breach the constitutional limitations on taxation privately, it's okay for you not to breach the statutes on taxation privately. If it's okay for Congress to create the appearance without the lawful obligation that you must pay income taxes privately, it's okay for you to exercise your constitutional and lawful rights to generate tax-free income privately. If the U.S. Supreme Court says it's okay for you to arrange your affairs so that your taxes shall be as low as possible, it's okay for you to arrange your affairs so that your taxes shall be as low as possible. If the U.S. Department of the Treasury says it's okay for you to pay no more than the correct amount of tax or only the amount of tax legally due, it's okay for you to pay no more than the correct amount of tax due under the law. If the U.S. Constitution and all three branches of the U.S. government say it's okay for you to make tax-free money, it's okay for you to make tax-free money.